Hello and welcome to episode 6 of season 3 of the Labor and Employment Podcast. My name is Lee Jacobs, and it's my pleasure to, as always, be joined with my colleague, Rosemary Enright. Good morning, good afternoon, and good evening, Rosemary. How are you?
I am great, and I'm broadcasting live from Studio B once again in Buffalo, New York.
And I'm down here in New York City in the Radio City Music Hall right across the street from the Rainbow Room and all the other good stuff in NBC.
See, I got to come and hang with you in New York, Lee.
You should. Though I'm going to be coming up to Buffalo, I think in the next 2 weeks or so. So maybe we should record in person. We'll have to talk offline.
Oh, that's a great idea.
But this is part 3 of Building Bridges, the art of employee onboarding. Excuse me. If you've made it this far and you've listened to episode 1 and episode 2, you'll see that Rosemary and I went on so many tangents and giving more information, and we're interrupted by not 1 but 2 fire alarms here in New York City. So we've broken the episode up into 3 parts. And as customary, I think even though we're going a little out of order, some fun facts. So my fun fact for this episode is as follows. You'll hear that I've talked about over the different episodes that the practice of law is open book. You've heard me say, I tell my students this. My fun fact is this year marks year 17 of me being an adjunct professor at Brooklyn Law School. My life has changed in so many ways over the last 17 years. People have come in and out and back in my life. I've changed in so many ways, but one of the guiding constants has been my work at Brooklyn Law School and with younger lawyers. I love it, and I truly do believe the practice of law is open book, and young lawyers are shaped by older lawyers, and I truly do want to pay it forward to every young lawyer that I come into contact with.
Wow, I'm just going to sound so shallow now.
No. I like this fact. This is good.
No. And I just want to say, I think that's great. So I teed it up a little bit saying that I'm here in Studio B, so in Buffalo. So my fun fact is, as you might expect, I'm a Buffalo Bills fan. And a diehard Buffalo Bills fan. I've watched them my whole life. I lived through the 4 losses. Yes, the 4 losses. Never get over that. And no, for all of you sitting there listening, the window has not closed. Despite what everybody's saying, the window has not closed. But actually, the real fun fact is, as you may or may not know, Lee, they're building a new stadium. So the stadium where the Bills play has been there, I don't know, maybe from the 60s or 70s. And quite frankly, I love it. It's one of the old school stadiums, and it's outdoors completely. There is no covering at all. So we're hardy folk here in Buffalo. So this Friday, I will be going to, they've set up, you know how they have model homes, that you go through when you're looking at a place, or model apartments or condos. They have got like I don't know what they're calling it now, but there is a place that we go, and they have a model of the stadium. Obviously not a huge, like an apartment or house, but they've built a whole model, and they've got all video and 3D and everything. And so we go and pick our seats, because I'm a season ticket holder. So I'll be doing that this Friday, and we have to buy a seat license. So that's a thing now that a lot of the teams are doing, Lee. So you buy a seat license, and that license then gives you the right to buy tickets. So the license isn't the tickets, it's actually the right to buy the tickets, and then you got to buy the tickets.
They get you coming and going, don't they?
That's exactly right. But I just love that I'm going to see this model of, and the company who is designing it, I think, is the same company who might have designed the stadiums like SoFi out in LA and the one in Vegas and that. So, and it's still going to be open air. There's going to be partial coverings in that. But that's what
I want to hear back about the if you still need to bring in a volunteer, or they get paid, right, to shovel the snow out.
No, that's right. Yeah, they get paid $20 an hour to shovel snow. That's right.
All right. Well, listeners, please enjoy the continuation of this episode. And as always, if there are any questions or concerns, please reach out to us. We're here to help. And you'll hear the message that is contained so often through what we talk about. An ounce of prevention is worth everything. Please let us help you. So enjoy. Coming back to the themes from what we talked about in the prior episode, that's why it's important in my mind to have the same people do the onboarding, so the same processes, and therefore the same mistakes happen. And therefore, so when you have to catch them every couple of 6 months or so, I would say at least you do an audit of these processes, a spot check, so you can fix them. And I know may not be you're not going to fix the problem, but you can stop the bleeding. And I know that's not necessarily a good phrase, but we want to stop the bleeding here.
Yeah, exactly.
On these cases, on these issues. So anything else about the wage acknowledgement form before we move on to another one of the micro machine lists that I read on?
No, I think everybody gets our point on that one, but it was so importantly for us to take the time to talk about that.
I think I do too. So job applications. And again, we could do a whole episode on job applications.
And we will.
So, Rosemary, job applications, we can do a whole episode just on them. But before we talk about the specifics, do you advise clients to use applications even in the first instance?
I've never had anybody ask me that question, but if someone did, my answer would be yes. I would have them use job applications. And you may ask why. And I think in our previous episode, I talked about it, Lee, in which we had a discrimination charge, and the EEOC came in and said, show us your job applications. All right, we want to see for the past, and I can't remember, the record keeping requirements for that. I think it might be a yearly. Don't quote me on that, but I'm pretty sure it's a year.
I think you're right. Again, don't quote, but think you're right.
I think it's a year. And so they said, show us your job applications that you have received. So I'm not talking the application form you use, although I'll talk about that in a minute. And they didn't have any. And the EEOC, of course, said, okay, well, you're supposed to keep them for a year. And we lost our discrimination charge because we took the position that we were interviewing individuals from all different backgrounds, but we couldn't prove it. Right. And the complainant said, no, they don't. In fact, when applications from certain types of individuals are brought in, they just throw it in the garbage, which was not true. But we could not. There was no way to defend against the claim because we didn't have the applications. So again, when I'm thinking about down the line, it's not a problem now, but it's not a problem until it becomes a problem. Exactly. So that, and then the other thing I was going to say is what we are getting more and more of, Lee, and I don't know if you are, is with the discrimination charges from the EEOC in particular, every time they are now asking in their request for information as part of the standard process, provide us with a copy of your current job application. And so, I want my clients to have that information, to be able to respond and to show that we made a decision based on, the qualifications and the skills and the experience of this person and nothing else.
Yeah, once again, Rosemary, in full alignment. Yeah. The practice of law is open book. I Googled it and I verified, went to the EEOC. You are correct, 1 year.
That's what I thought.
Your record keeping requirement is 1 year. But when I have, in the hospitality industry, I have a small coffee shop ask me, I've got 6 employees. Why on earth do I need an employee application? Like, what's the point? And the point of it is, as I think you put it best, is that when you're faced with the discrimination, harassment, whatever lawsuit you may have, this proves what you knew about the employee on day 0.
Mm-hmm.
And without that, it's going to be a much harder fight for you to win. So if you do use an application, which we think you should, the application tells us what we knew of the employee on day 0, and it helps us defeat claims of wrongful treatment or whatever may happen in the future. But what I find then is what happens is that you have this competing force, is that clients, business owners, okay, I need to use an application. I'm just going to Google and I'm going to download an
Oh,
application from exactly download an application from the internet. Why is that a bad thing, Rosemary? Why did that make you have that visceral reaction?
I'm sorry about that, Lee. Isn't that funny that I reacted that way? Um,
Exactly. I had the same one. I led you to where I wanted you to go.
Oh, is that what it was? Yeah, well, so because for the very reason, the some of the items that we talked about in our previous podcast. All right, you've got some random job application out there that has a whole series of questions or requests for information that we shouldn't be asking about, and quite frankly, you don't want to know about. All right. You don't want to know about. I don't want to know the age of someone. I don't want to know when they graduated from high school. I don't want to know if they've been have a prior criminal conviction. I don't want to know their previous rates of pay. I don't want to know any of that. And all of that should be irrelevant in the hiring decision. Right. And so, so you want to make sure that you have an application that, first of all, reflects the information you truly need, right? So, because everybody's different, that 6-person coffee shop, Lee, is going to be looking for something or needing something very different than, for example, our law firm or Oracle.
Exactly.
I talked about Oracle the last time, right? So it should be specific to your organization, and you need to make sure it is compliant with state, federal, and local laws. And the reason I point to local is, ban the box, which is the question on the application as to whether you have been convicted or you have a prior criminal conviction, right, is not statewide yet. It will be, I'm sure, but it is on the local level. So I sit in Buffalo. And so ban the box, that's what it's called, is in effect in Buffalo. So companies in Buffalo can't have it on there. But if you go outside Buffalo proper and go into any of the suburbs, it's permissible out there. Now, of course, we advise all of our clients to remove it. But still, so it's local, state, and federal law. You want to make sure your application is compliant with that and it's specific to your organization, and downloading some generic form is not going to get you there.
And you will lose a lawsuit on day zero.
Yeah.
Because if that application asks for, prior wage history, asks for age, asks for this, and someone applies and they are an older person and there's no need for it, you may lose the fight on day zero.
Mm-hmm.
Next one, job descriptions, offer letters. Do you think they're, one, necessary? And if two, how do you advise clients to go forward in creating them?
Yeah. So the same thing. Don't go out and Google sous chef and the job description and download it. Do not do that. All right. Again, you can do it and start with that.
Exactly.
But again, it should reflect the actual duties and responsibilities of the individual in the job. And Lee and I could talk about job descriptions for multiple episodes. So from my perspective, absolutely necessary. All right. It is how we are going to evaluate someone. It's how we train someone. It's how, if someone needs an accommodation,
Mm-hmm.
it is how we then can make the determination, is this an essential function or not? And how might we accommodate that? So, I mean, there's a whole host of reasons you want a job description. Again,
And
go ahead.
Do you want the employee to sign it too?
What's interesting is I can go either way on this. Generally what I'd say is I'd prefer that it's signed and dated, because again, then I can say that we sat with this individual and that we reviewed the essential functions of the job. They fully, understood the expectations, and they indicated they could perform all of these functions. So, I would prefer it. But, if you haven't done that, I'm not going to lose sleep over it and say you've got to go back. Unlike the wage notice,
Exactly.
we just went through and we said you got to go back. With this, you don't have to. I wouldn't say you have to go back. You may disagree, Lee.
So I think you've got to, again, one of those things where you got to take an internal look at your business and your job force. I think Oracle, maybe I could be wrong, not necessarily they probably required you to sign it because it was a business process. But
Mhm.
I think everyone knows or I would assume everyone knows what a systems computer programmer, blah, blah, blah does, right?
Yeah.
But I'm thinking of some of my clients, that's 6-person coffee shop, the porter, who is the person who cleans the back of the house. A porter could be different from one spot to another.
Mhm.
And then there is we were just at a partner retreat, and we had a generational divide and differences session. And Generation Alpha, the newest generation, they will speak up for themselves as they should and make sure their rights aren't trampled over. And they will say, and I've been hearing this in my hospitality places, because you can hire people as young as 15, 16, depending upon what you do and the time of year, that's saying, this isn't in my job description. You can't ask me to do this. So I advise clients to say that and so like porter, and being asked to do things consistent with what a porter would do. So you
That's
get a
right.
catch-all, because
Yeah.
employees think, especially the younger ones, I have a document that says this is what I'm supposed to do, and I'm going to do nothing more and nothing less than that.
Mhm.
So
Yeah.
I think job descriptions are super important.
Yeah.
Um, what do you
And
think about offer letters? Oh, sorry, Rosemary, you're going
yeah,
to say
no, I
something.
was going to say offer letters because I knew you wanted to talk about that. I know you
Yeah, what do you
wanted to
think
talk
about
about.
offer letters? Do you think they're important or required?
So required. New York State and Fed don't really care about it. But I do like a simple conditional offer of employment,
Yep.
and the key there is that it's a conditional offer. And it may be based on a variety of things. Maybe it's reference checks. Ability to present documentation showing you are permitted to work in the United States. They all should, quite frankly, be conditional based on that. So, but you don't want to include everything, including the kitchen sink, in that conditional offer
Yep.
letter. It's a high level. Here's your job title. Here's your start date. Here's your starting rate of pay. And there's a few other things. I don't have to go through them all, but yeah, and I would have them sign that. So, it's signed by whoever signs the offer letters, the HR person, the CEO, and then ask them to return it with a signature and a date. So, yeah,
I
I'm good with those.
I advise, and I like to think of it in the sense of the documents that are required for people is almost an inverted pyramid over your pyramid of your structure. So
Yeah.
those at the top get more documents than those that are at the bottom of your organizational structure. So
Mm-hmm.
everybody, no matter where you are from top to bottom, gets the I-4, the W-9, the wage acknowledgement form, your handbook, acknowledgments, the
Yeah.
poster, note, everything we're going to talk about. Then as you move up the chain, then in my mind, we're thinking, okay, everyone gets a job description. Does the porter in the back of the house of a 6-person coffee shop need an offer letter? Probably
Probably
not.
not.
Probably not.
Yeah.
But does a mid-level employee in a large business require an offer letter? Probably yes, right?
Mm-hmm.
You gotta think about it as you move on. And then as you move up the category and now moving to some other documents, Rosemary, we're talking about everyone gets a handbook, obviously, about confidentiality, non-solicitation, non-compete agreements. What are your thoughts on those? Do you like giving those out in generalities to employees?
No. Well, because you use the word generalities, right? So
Yeah.
no. So the use of those, what we refer to them as collectively as restrictive covenants. So those have got to be specific to the job. Right. And so, there's the famous case that everybody knows about. Was it Jimmy John's that they had the individuals who were making the sandwiches had them sign non-competes, that they could not go and work.
I think you're right. I'm going to check that as
Yeah.
you continue
I
on, but
think it
go
was,
on.
I'm pretty sure it was Jimmy John's. All right. So clearly an individual who works at Jimmy John's
As
or,
usual, you're correct.
yeah, thanks. And Subway, a non-compete doesn't work there. All right. And quite frankly, neither would a non-solicitation. Now, Might confidentiality, even that's a bit of a stretch, but if there's some secret sauce at Subway or Jimmy John's and you don't want people to share that, if the Anchor Bar here in Buffalo with the secret sauce that they use, maybe something around that. But as a general premise, I'd say no. I do not say that when people come in, I'm going to hand them these 3 documents that they have to sign. It's got to be far more individualized. And it depends on the industry and what they do. Like you said, your porter in the back of the house,
doesn't need it. And I agree with you fully on this. And that leads to, my last question in this, in the general documents as we're moving higher up the pyramid, contractual employees. Who, in your opinion, should actually receive an employment agreement or a contract as opposed to just the slew of other documents that we give them when they start on their employment? I know it's a loaded question, and I'm curious to see where you go.
I was just going to say, that's literally what I was going to say, that is a loaded question. Wow. So here's what I'd say. If we're talking about it contractual, so I would say, as an easy answer, a quick answer, my C-suite. All right. So my C-suite, I'm going to have a contract for them because there is probably a severance in there somewhere. Yep. There may be arbitration as we talk. I mean, there's a whole slew of things that would be specific to an individual at that level. So I think, I say in what that game show final answer, I don't know that that's my final answer, but that would be my initial answer. And if y'all can't tell, he and we make a point of not rehearsing these so that you can see, I'll say, well, I got to think about that, and I'll do the same to him. So anyway, you go ahead. What's your answer?
I love for everyone to see how the sausage is made in many respects.
Yeah.
And I tell my students at Brooklyn Law that the practice of law is open book. You want your lawyers to be thoughtful and think about things and not come to a rote answer the way that it's supposed to be every time. And that's why people hate us sometimes because the answer is always, it depends. So for me, when I get my clients come to me, I want employment contracts for my employees. And I say, no. And they say, well, I want an employment contract. And I say, again, no. And they say, I want an employment contract. I said, convince me. Tell me why you need an employment contract for someone, because as we spoke about this in the last episode, 2 episodes ago, as a reminder, everyone's presumed to be at will. You owe them nothing. They owe you nothing. There is no requirement to give someone 2 weeks notice, to give severance, et cetera, et cetera. So why give your porter a contract and now you owe them something more than just a termination that is lawful? You didn't do it for bad reasons.
Mm-hmm.
Don't do more. Don't give more. But I agree with you, C-suite, regardless of your organization, when you're at the top of your pyramid, no matter what kind of business it is, those are the ones that I will say yes. Mm-hmm. Anyone below that, you got to convince me. Yeah. You got to convince me because it's got to be the right business decision. You don't want to be giving away more than you need to your employees.
Exactly. And, and keep in mind, you can always, I've had some employers who've said, I want to give them an agreement because the employee wants one, Lee, right? Because somehow they feel, I want some sort of something in writing more than just an offer. And so I have drafted employment contracts. I use that word loosely, in which it states that the relationship is at will. Yeah. And so, and basically all the contract is doing is memorializing more terms and conditions of employment than what would typically be in a conditional offer letter.
Yep. I think that's a workable thing, but and a good idea. And for our international listeners, always, as what's different between America and a lot of other countries that our clients work from, employees are presumed at will, and that is. Whether or not you, on a personal side, think that's a good or a bad thing, that's the foundation of our employment relationship here in the country. Yeah. And you never want to change that, period. Yeah. Hard stop.
Yeah.
Okay, so Rosemary, I'm going to go very quickly through some hospitality stuff.
Great.
Good. That is also required on onboarding day 1. So very first, tips. Tips. When you are a restaurant, a bar, and you receive tips, You are holding those tips on behalf of your employees. They are not yours. Point one. Point two, and I'm going to use New York upstate numbers outside of New York City because the math is easier. Minimum wage is $15 an hour with a tip credit for $5 an hour for an effective rate of $10 an hour. You do not pay your employees $10 an hour. You pay your employees $15 an hour with a $5 tip credit for an effective rate of $10 an hour. And you are allowed to do this, take a tip credit of $5 an hour when your employees are tipped when they make more than at least or more than $5 an hour in tips over the course of their shift. So if they make enough tips to bring them back above $15 an hour, minimum wage for the entirety of the shift, you can pay them $10 an hour. If they don't make it enough in tips, you have to bring them back up to $15 an hour. In a requirement in order for you to be able to do this, to pay your employees $10 versus $15 an hour, is you must have a tip sharing agreement. And that tip sharing or tip pooling agreement must be in writing, identify where the money coming into the tip pool goes, when injections of cash come in, when they get ejected out, where it goes, and 5% here, 10% here, 12% there, whatever it may be. That's important and required from the onboarding perspective. There are other things that are required for tipping about tip pool requirements, record keeping requirements that won't touch here because that can be a whole episode on its own. But note that you have to give the tip sharing, tip pooling agreement on day one, or you cannot take the tip credit. Hard stop.
So Lee, let me just ask, just like everybody,
Sure.
Our listeners, they can go out on the Department of Labor website and they can download the notice of pay rate form that we went through. So what about this tip, sharing or tip pooling agreement? Now, where do they get it, Lee? What are they?
These are there's two places generally where I've seen people get them. It's either word of mouth, that this was the form that I used when I was an employee or before I bought this business, or this was the form my father used, or whatever it may be. And they could be right or wrong, and where I've seen them be wrong is you include people in the tip pool who shouldn't be there, like managers, supervisors, back of house people. Or they get it from us. They get it from me. They get it from other industry professionals that know the how it works. And I think you said it earlier, Rosemary, there is absolutely no need to reinvent the wheel. Tipping in New York has been happening since forever.
Yeah.
And these forms and templates exist. Just find the one that exists that works right for your business. And we can help you work it out and make it the right way. Okay, uniform acknowledgments. So this is not necessarily hospitality, but it can be anywhere where someone is given uniforms or equipment or things of the business. If you are giving your employees things that are yours that you expect them to keep in good condition and to give back to you at the end of employment, you have to give them an acknowledgement form that they've received it, they understand that it is not theirs, they're going to keep it in good care and return it at the end of their employment. And that's really it when it comes to hospitality. There are two other topics that I want to talk about for paperwork, and then move into New York City based things. The first is a direct deposit form. We had talked about that anecdotally before, Rosemary.
Yeah.
Do you like direct deposit forms? Do you think they're a good thing or a bad thing?
So, a direct deposit form, in other words, I've got to fill it out to say this is my information. Yeah, I'm being literal there. I'm busting his chops. But I'm good with that. I'm good with that. But what a lot of people don't realize, listen up here, if you're out walking the dog and, you're not totally engaged, New York State does not permit employers to mandate direct deposit. Right. So yes, you heard that right. So I can't tell you how many new employers I start working with, and I get their employee handbook, and it says right in there, direct deposit is required. Okay. It's a violation of the New York laws. All right. They have to be given the option. All right. You can recommend it. You can encourage it if you want to, cannot require it. So do not require direct deposit. And one of the things that Lee and I were talking about with this, besides the fact that you need to comply with New York's laws, is if you're doing direct deposit, then your people aren't seeing what they're being paid. And just like in our last episode, Lee made reference to the Wage Theft Protection Act, which requires that notice of pay rate, which we just talked about. It also requires that your employees get a wage notice, and it's prescribed what goes on that notice. Now, a lot of probably our listeners work with ADP and different payroll companies. They know what New York State requires. But the point is, if you're doing direct deposit, your people may not even be looking at it. And so if there are errors on there, if there was a deduction taken erroneously, or they're short paid, or, one of your manual workers, the punch wasn't right or something, and now they're short paid. Now, and then they find out X number of months down the line, it just opens a whole can of worms and creates headaches where you don't need them. Again, I'm not saying you shouldn't do direct deposit, but it's a consideration.
Where I've seen the wheels going off the cart in this scenario is in two places. The first is, you have a population of employees that don't have computers, don't have iPhones, right? And now you're mandating them to use direct deposit or highly suggested or whatever the words you want to use. And you know that they can't access it because they don't have computers. And the law requires you to give a pay stub, the wage notice, with every payment. Mm-hmm. I once had a cause of action. It wasn't sustained, but it was a cause of action that was brought that said, you knew these people weren't getting their pay stubs. So you should have printed them out and given it to them. So I tell people now, as part of their processes, if you have ADP, you have Paychecks, you have the big payroll companies, they can run an audit and see who has actually logged in and gotten their pay stubs. I can see a nefarious plaintiff's attorney making an argument saying you should have known better. The law requires you to give a pay stub, so give the pay stub.
Yeah.
And the other thing I would say to Rosemary is I would be even a bit more explicit as what you say is that you cannot fire someone because they want to use direct deposit. You cannot deny employment revoke an offer because they don't want to use direct deposit. And this is the same true here in New York City as a little bit of a side. That's why we have cashless bans. Restaurants and bars and stores must accept cash. The state has a large population of people who are underbanked, that don't have banks, don't have banking accounts, don't have checking accounts. And so if you're forcing someone who doesn't have a checking account to do direct deposit, how are they getting paid? Right. Then you're going to say to yourself, well, Lee, if they don't have a checking account, then how are they getting paid anyways? They go to check cashing stores. And that's how they get those checks cashed. So to mandate someone to use direct deposit means they have a bank. And that's a problem in New York. Not everyone has a bank.
All right, what did you call it? What did you say they call it in New York City? What did you say?
Cashless ban.
Cashless. Wow, interesting. I will admit I did not know about that.
Yep, you cannot. If you walk into a restaurant, a bar, a grocery store, a place of essential services, you cannot demand credit card only. And if you are a cashless store, you have to I have a number of clients who set up an ATM, think of like a laundromat kind of system.
Okay, yep.
Where you can load cash into the system, and then you get a card where you can deduct values from it. And they're good business reasons for it. Think about it. Any city where you are late at night dropping off cash, no employer wants that.
Right. Yeah. Got it. Interesting.
Both sides of it. So, and then New York City has a form that I want to tell you all about. It's called the New York City Commuter Benefits Form. I think this is a great thing that should be, put everywhere. New York City mandates employers to give their employees the option to take out of their paychecks, pre-tax, money to pay for commuter metro cards, accessoride, tolls, bus fare, ferry fares, public transportation. You can pay for it ahead of time and pay for it tax-free. And you're mandated to give this form to your employees on day one when they get onboarded.
Wow, that's interesting. That's great. I agree with you.
It's
All
a
right.
good thing.
So Lee, I think it might be helpful. Just do a day one, these documents, because you just said that's day one. So just with our
Sure.
list, just tell them day one, this is what you must do.
Day one, I believe if there is a job description and you want an acknowledgement for it, you're acknowledging the job description. If there's an offer letter, you want them to acknowledge the offer letter. W-4, taxes. I-9, immigration. New York State wage acknowledgement form. New York City, if we're a New York City commuter benefits form. Direct deposit form, if you're using it. In the hospitality industry, uniform acknowledgments, tip pool agreements. If you're using them, confidentiality, non-solicitation, non-competes agreements. Handbooks, an acknowledgement that you received your handbook. And then that's day one. And if you're over 100 employees, day one is also the EEO1 self-identification survey form, where we're asking the employees to identify their racial background and makeup for the government.
Right. Which is
And then,
voluntary, which is
which is
voluntary, which
voluntary.
everybody, yeah.
And then day two and after, can be where we haven't spoken about it, but day two and after is where they're getting the training and you're getting acknowledgments of training, and particularly in New York State, sexual harassment training.
Yeah.
That happened, and it's there, and the certificate goes in their file.
Yeah, exactly. And then Lee, I think the next thing, I don't know where we are. How much time do we have left, Lee?
It's been for dear viewers, we've had 2 fire alarms go off here in New York City, so I'm not sure the actual time. We have some other topics to talk about.
That's what I mean. That's why, because I wanted to hit on just quickly, like these notices, because because
I think we can go through them. I think what we should do is we'll go through them quickly, and we can make the notices available on the website.
okay, I think that's a great idea. So Lee, let's, I'll put you on the
Please.
spot. I'll put you on the spot. So the first one, so y'all know, I've got our list here so that we don't forget anything. New York State requires that on day one, you give notice to your employees of your lactation accommodation policy. Now, do you really have to give that to everybody, Lee? I mean, you've got, a person who, I'll just say someone who self-identifies as male. I mean, does he care about lactation accommodation? Are we required to give it to him?
So the answer to the question is, I don't care the reasons, but yes, you give it to everybody. I can give it from an administrative auditing place. You onboard every employee the same way. So it's the same. So if the same mistakes happen, we can fix the same mistakes. And then as we move to this particular employee, you're sitting across from an employee who may self-identify as a man, but you don't know what can or cannot happen in the future. He needs those rights. And more importantly, what if this employee becomes a manager or a supervisor in the future? They also need to know this information, because they will then be tasked with making sure that employees, maybe years later after they've been onboarding on day one, now needs these notices and these rights. Because so many things in the employment practices realm, it's on you as the employer, the supervisor, the manager, to listen for the magic words, not for the employee to come to you and say, hey, I need this. So yes, give it to everybody. There's no reason not to.
Exactly. And so, I'll have, employers ask me, Lee, they'll say, well, isn't it enough if I just hand them the handbook and it's all in there? Why do I have to give them? And we'll talk about that, some of the other notices that you actually have to present on day one or day two. So what do you think, Lee? What's your answer to that question? Why do we have to actually hand them certain notices and can't just give them the handbook?
Well, one is because the law requires it.
Mm-hmm.
The law explicitly says that you must give these things. And then, and I advise, one, it's in the handbook too. The notice is also there. And then there's an acknowledgement that says you read the handbook. And then on the bottom of the handbook acknowledgement, it says, I also received the following notices. So from a bare reason, you are required to give the notices by law. But I think as a practical reason, there is no requirement to have a handbook in New York State. So New York is a very employee friendly state. It just is. So for those employers who don't give a handbook, here is how the state is saying these are the important things we want our employees to know about.
That's a brilliant answer. I love that answer, Lee. And the other thing that is kind of lesser, but I'd add in there is, you hand somebody an employee a handbook that's 50 pages long. Are they going to sit there and read it? Let's just be honest. No. And so precisely. So by handing this to them and it's short and sweet, lays it out, that they understand and that they've been.
And then I think also the last point is then you're thinking now from the mindset of an auditor or an investigator, they want to see the form. Make the job easier for them. The form looks a certain way. I see the form. It looks that way. Done. Next. Move on to the next thing.
And Lee just hit on a great point there with the auditor, because you may think, oh, my employees are all happy. No one's going to go to the Department of Labor and complain. But realize the Department of Labor also, I don't know how it does it. I always do this motion, Lee. I don't know why, but there's some random number generator and it's going to throw out a number. And oh, guess what? Today, Barclay Damon gets picked for just a random audit. And they're going to come in and they're going to go through. And again, they're looking for all of these things. Make it easy for them and don't make it hard on yourself, because this is all so easy to do.
I agree. And also just as a clarification here, what we were talking about before in the prior section are forms that your employees need to fill out and return to you.
Good point.
Here we're talking about notices that you just give. They don't have to do anything, but you just give them to your employees.
Other than sign the acknowledgement, Lee.
Correct. Exactly.
Yeah, exactly. That's a great. Thank you for making that clarifying. You're right. Everything else they're filling out. This one we're giving them notice. What about background checks? All right. If an employer does background checks, any notice that we need to be giving?
Yeah, I think we need to start from the job posting that says a background check will be part of the application process. If there's a conditional offer letter, if you're doing a background check, there needs to be a conditional offer letter, that says that you've passed that says you must pass a background check. And then once the background check comes back, there are certain things you must do or not do. So I'm going to ask a question to answer this question here, Rosemary. Are we talking about criminal background checks? Are we talking about credit background checks? What kind of background are we jumping into?
I'd say both. Yeah, both.
So in both instances, if you're doing a credit check, you need to give a Fair Credit Reporting Act notice to your employee. If you are doing a background check for criminal interactions with the criminal justice system, this is everywhere from arrests through I've been in jail, served my time, and all the ways through the end. You must give them a notice pursuant to New York State's Correction Law, Article 23A. I get into this debate eternally with my clients. Why are you doing a background check? Why? Because there are so many hurdles we need to jump through in order to, if we want to do it, what's the point, right? Are you really going to not hire someone because he got a drunken intoxication and he urinated outdoors when he was in college? Are you really not going to hire him for that? You want to go through this whole rigmarole for this? I try to focus in on the job description and the job, and then what would be the disqualifying things before having a blanket background check policy. But again, every industry is different.
That's what I was going to say. That's exactly right. I was going to say, you've got, I guess you'd call it the healthcare industry. I work with a lot of employers who have home health care aides and, PCAs. And so there are requirements there. I work with several schools, obviously requirements there. But your
bus drivers,
exactly.
Transportation companies, there are requirements. But,
absolutely.
But if you're a line worker in a factory, a porter in a restaurant, a salesperson in a store, what for? What's the point?
And why open the door? Why open the door? Exactly. So go ahead.
And as I say, the whole point of this, the public policy, is that New York firmly believes people are due a second chance. And that comes to the New York City, which is even expands it even further on this background checks as it relates to criminal histories. That it's called the Second Chance Act here in New York. Mayor Adams made it a big part of his thing that if you've been convicted and you served your time, unless there is a direct link to your criminal activity to your job, you should continue to have your job, or you should not be turned away from your job, because everyone deserves a second chance. And if when the background check comes back negative or bad, and you don't want to hire, or you want to now fire your current employee who has just been arrested for a domestic violence situation, you then need to give to that employee, had this happen, an reasoning as to why their DV arrest disqualifies them from continuing to be a bartender.
Yeah.
Can you link the two?
Yeah, well, that's right. It makes sense.
It does.
It really,
does.
yeah.
And more New York City nuance. But back to you with the list, Rosemary.
Yeah,
Apologies.
yeah. Well, and the interest, I don't know, because again, listeners, we had to stop because of 2 fire drills. So I'm not sure on the timing here. So I don't know that we want to talk in great deal about everyone. I'll let Lee go through the list, but I just want to talk about one quickly, a notice in particular, the electronic monitoring, Lee.
Yes,
yeah.
Please
Okay.
do.
Yeah. And so if what I say to clients is, if you think at any point you are going to be monitoring your employee's email, or you might go into someone's email or their voicemail, or you distribute phones, all right, you give them cell phones, all right, and you might be monitoring their cell phone usage. So anything electronic. So you need to provide those employees with an electronic monitoring notice. And again, New York has made it very simple. Also, we have it. We can flip it to you in a second. It's very short and sweet, but on day one, you need to hand the employee the electronic monitoring notice. It's 1 or 2 sentences, and it says you should basically be aware that we will, or we do, monitor, and it lists, I keep hitting the mic, sorry. It lists everything. And they sign off on that. That is for every single new hire. All right. And I can't tell you how many clients, when something comes up and they say, all right, well, we want to go in and look at this employee's email. I ask them, all right, have you given them the electronic monitoring notice? No, I don't know what that is. All right. Well, you know what? But I do have this thing that there's no expectation of privacy. I get that. But you don't have the electronic monitoring notice. I'm not saying you can't look, you can't check, but you're in violation of the law. You've got to give them a notice. So all your new hires get that on day one. What about, and if you're sitting there thinking, oh my gosh, I haven't done this, don't worry. Current employees, you are not required to physically give them a notice, right, Lee? So with your current employees, as long as you post the notice, and again, I'm very, so here's your bulletin board in the cafeteria, the electronic notice is posted there. The electronic monitoring is posted there with all your wage and hour. All those, it's up there. It's also in the handbook. So for current employees, that is enough notice. But all new hires must be actually given the notice, and they must sign off on it. So, and I just see this, it comes up weekly, Lee, which is why I wanted to bring it up. I just thought it was, I don't know if you want to add anything to that.
I think that's crucial, because it's one of the newer ones that are out there, and the other sides and employees will always pick at our weaknesses and try to get there.
Yeah.
But to go quickly through this, so here are your notices to be provided at hire: New York State lactation accommodation, electronic monitoring, our background check notices if we're doing them, Fair Credit Reporting Act under the New York Correction Law, Article 23A, New York City's Second Chance Act notices and procedures. And then when we are New York State, the Pregnancy and Employment Rights Notice. New York City also has a Pregnancy and Employment Rights Notice. And again, give these to every employee. Then New York City has an Earned Safe and Sick Time Act notice of employee rights that must be given to your employees. And there is also in New York City a Stop Sexual Harassment Act information sheet that must be given to your employees. And as the last thing, I'm going to quickly go through this for time purposes. As Rosemary was saying, there's now your posters, right? So now we're onboarded. Our employees have now left. They've filled out all the paperwork. They've received all their notices. Now they're in day 2, eating lunch in your employee break room. They should look up and they should see posters. And on the posters, there should be a whole bunch of them. And we'll put a list up on the website so you have them. But there should be, as Rosemary said, what applies to pay, minimum wage, how you get paid, when you get paid, human rights laws notifications, unemployment insurance law notifications, workers' comp, paid family, disability, and both English and Spanish, by the way. Workers' comp, Clean Indoor Act, employment of minors, voting leave, construction industry Fair Play Act if you're there, criminal convictions records, Article 23A again, nursing mothers in the workplace, HERO Act, electronic monitoring, military veterans benefits and rights, expanded whistleblower protections, captive audience bans. That means about free speech in the workplace. In New York City, there are even more posters that you need to have up there because people think, my clients here in the city, well, ADP sent me the New York State poster that has all those things in it. That's enough. No, no, no. You need to go onto the New York City's websites and download the following. Living age for assisted workplaces, wage, excuse me,
I was
for
just say,
assisted
what is
workplaces.
living age?
So if you are an employer where you hire and you know that you are employing people who receive public assistance, there is a living wage notice that must be given. There's a New York City human rights law notice that must be given. The Earn Safe and Sick Time Act must be posted. Automated employment decision tools, a new one that has just come out. Workers' Bill of Rights must be posted here in New York City up on your walls. And a temporary schedule change law, which applies to certain industries here in New York City, must go up on the wall. I tell my clients, these things, they go up on the wall and they also go in your handbook. Why? Because that way we are covered.
Right.
For whatever reason, you have a remote employee who never shows up in your lunch break and they never see the voting leave notification. Well, it's in your handbook, and vice versa. So that's why everything is where it is supposed to be, in my opinion, everywhere.
Right. And don't forget, Lee, also New York State now requires all of those posters to be available electronically.
That is correct.
Yep.
Yeah. Not only electronically, you get that poster in from ADP where it has your payday information. It expects you to fill in what day is payday. You got to fill it in. Where there's the OSHA notification that says this is a safe workplace. This is our OSHA person. Fill it in.
Yep.
A blank form is a wrong form. Fill it in.
It's so funny you say that, Lee, because we were dealing with a harassment charge. And so the DHR asked for the complaint form, and my client, they came so close. They downloaded the complaint form that New York State has posted. Only problem is where it said, where you're supposed to insert like the company name and everything. It literally said company name, and that was what was in the parenthetical with the line, and then call insert representative. So all of that was just literally not filled in. And the DHR's response was, well, clearly they don't take it seriously.
In my opinion, I think that you would be viewed worse than someone who said, there's a form?
Yeah.
What? There's something I have to give out?
Exactly.
Because you knew and you ignored it. You didn't even read it.
Yes, exactly.
I think we've spoken about so much on this topic, but as you've all, and thank you for bearing with us, know that this is something that we can wax poetically for hours about. And with that note, we will continue to wax poetically about. And to that end, we thank you for joining us here for this episode as we continue our conversation about onboarding. And stay tuned. We have coming in the near future episodes about offboarding, how to properly terminate an employee and conduct exit interviews. We have future episodes coming up about how to conduct a workplace investigation and the right time, the right way to do it, and most importantly, when to call in for reinforcements and to seek outside help. But so the Spotify question for those of you that are out there listening today, it's just going to be a very simple one. After listening to us for probably over an hour over onboarding, do you feel you've got onboarding down pat? Yes or no? And if the answer to that question is no, please reach out to me or Rosemary. We want to help you because so many of these things that we've talked about, an ounce of prevention is worth so much more.
Absolutely.
Pick up the phone, shoot us an email. We'll help you get the right form, and then you'll never have to worry about that $50 per day penalty for $5,000 per employees that will last for 6 years.
I love how you got it all in that list. Yeah, exactly.
Please let us help you.
All right.
And with that, thank you. Thank you, dear listeners.
All right. Have a great day.
Thanks, everyone.
The Labor and Employment Podcast is available on barclaydamon.com, YouTube, and all your favorite podcast streaming platforms. Like, follow, share, and continue to listen. Thanks.